Today, I'm going to bring you a case that deals with a false confession. It actually deals with multiple false confessions. In fact, it so closely mimics the Central Park 5 case that it's almost a carbon copy. More about that in just a moment. Here's what we're talking about today. I came across this case a couple of days ago as I was researching other matters. And it struck me as just amazing that this could happen. And it's very much like what happened to the people in Missouri who were finally allowed to be free. This is a situation that just should not happen. When awful things happen to relatively famous people, or beloved ones of relatively famous people, the police seem to make an extra effort to bring the perpetrators to justice. Think about Paul Pelosi, for example. What happened to him was terrible, and if it happened to any other person, it would be terrible too. But when it happened to Paul Pelosi, they pulled out all the stops to find out who did it. Although we should always expect equal justice under the law, it would be foolish to deny that, in the words of the book Animal Farm, everyone is equal, but some are more equal than others. NBA star Chris Paul had a grandfather living in North Carolina. Mr. Nathaniel Jones, the grandfather, was assaulted and killed at his home. Police moved quickly to catch the people they believed to be responsible. On this channel, I've talked several times about the Reid technique. The Reid technique is an overly coercive method of getting people to confess to crimes they did not commit. Here is the process used in the Reid technique. First, it has three phases: factual analysis, behavioral analysis, and interrogation. Step one is a direct positive confrontation. The suspect is told in no uncertain terms that the evidence proves their guilt. We know you were there, the evidence confirms it, let's talk about why this happened. That removes the presumption of innocence. Suspects, especially young or inexperienced ones, may believe resistance is futile. The interrogator offers moral excuses for the crime in step two: accident, provocation, desperation. You didn't mean to kill him, you were scared. Anyone with a weapon in that moment might have reacted the same way. Minimizing guilt encourages the suspect to confess, under the illusion that the consequences will be less severe, which is false. If the suspect denies involvement, the interrogator interrupts or ignores them. I didn't do it. Let me finish. That's not helping either of us. Repeated denials are not seen as evidence of innocence, but as obstacles just to be shut down. Objections, I'd never do that, I have kids, or something to that effect, are reframed as signs of guilt or internal conflict. Right, you're not a bad person. That's why it's so hard for you to admit that you did this. This step often distorts the suspect's words, makes their protests seem like veiled admissions. And then they go after them by retaining their attention. The officer becomes friendly and encouraging. The tone shifts to empathy and camaraderie. I'm on your side. I just want to help you move past this. Yeah, right into a jail cell. Rapport building creates a false sense of safety even as the officer works to elicit a confession. Once the suspect withdraws emotionally or physically, the officer leads in with sympathy and emotional appeals. You've been carrying this weight. It's time to let it out. I know you're not a killer. This is the moment many false confessions begin, not out of guilt, but out of exhaustion. And then the officer presents two explanations, both of which presume guilt. Did you plan to shoot him, or did you happen to be there in the heat of the moment and it just happened? There's no option here to say, or are you not guilty? That's because the process is guilt presumptive. The suspect agrees with the theme, and often in a moment of confusion or submission, yeah, it wasn't planned, I just panicked, I'll tell you what you want to know. And then they get this confession. Now, up to this point, just as in this case, none of the prior interrogation is video recorded. Only thing that is recorded is the actual confession, and they get that on videotape. And that's the central evidence that's used against them in trial, just the way it was here. As you'll soon see, what happened to the 4 individuals that the police arrested was a product both of that Reid technique and, quite probably, a little racism thrown in. Amazingly, all of these suspects were 14 or 15 years old, with the exception of one, when they and another teen were arrested for the killing of Nathaniel Jones. Nathaniel Jones was gruesomely killed. It should never have happened. He was found dead with his hands taped behind his back and his mouth taped shut with black tape outside his house after an apparent robbery the day after 17-year-old Paul had committed to play basketball at Wake Forest University. Rashawn Banner, Nathaniel Cawthon, Christopher Bryant, and Jamal Tolliver, along with another man named Darrell Brayboy, were arrested by police and interrogated. Between the afternoon of November 19, 2022, and the early morning hours of November 20, 2022, the defendants and Brayboy were interrogated for the murder. After the interrogations, where confessions were obtained, they were indicted for first-degree murder, taken to trial, and convicted. They were given life without parole. Now, 2 of them were not convicted of first-degree murder. 2 of them were convicted of second-degree murder, and I'll get to that in a little bit. Let me read you some of the facts of the interrogation. Mr. Tolliver was released from prison in 2017. Tolliver stated that when 2 officers arrived at his home around the time school let out, he admitted them to his home and they talked to his mother in her room where he could not hear them. Mr. Tolliver said that when the officers asked if he wanted to go to the police station for questioning, he agreed to go because he had nothing to hide. According to Mr. Tolliver, they did not say what the questioning was about. Mr. Tolliver stated he had never had to go to a police station prior to the interrogation in this case. Mr. Tolliver stated the first question the officers asked him during the interrogation was about Mr. Jones' missing wallet, which the officers told him Mr. Jones' daughter reported missing. Tolliver told them he didn't know what they were talking about. Tolliver stated the officers were wearing plain clothes instead of uniforms and they had guns on their waist. Tolliver denied involvement in the crime when talking to the officers. Mr. Tolliver stated the officers began to raise their voices and say they did not believe Mr. Tolliver was telling them the truth. Tolliver said the interrogation seemed long. He said that he asked to go home at some point, but the officers said they weren't done questioning him yet. He stated he needed to go home again because he got to be tired. Tolliver said he believed things the police officers said. Tolliver stated he eventually lied because the officers were not believing what he said and he thought it would help him. He told the officers he and some of the other defendants threw the wallet out the window of a city bus and onto a field by the mall. The officers took Tolliver to a McDonald's close to where it was believed the wallet should be. Tolliver said the officers kept him in the car and got him McDonald's while they searched. No wallet was found, and Mr. Tolliver said he began to think the officers would figure out he didn't know anything because the defendants did not commit the crime. Mr. Tolliver said the officers looked frustrated and asked him more questions about where to look for the wallet, and then they took him back to the station. Mr. Tolliver stated he did not see Ms. Black or the other defendants while he was there. Tolliver said he used the bathroom once at the police station and the officer was present when he did. Tolliver stated the officers told him if he said what he wanted them to say, he could go home. Mr. Tolliver said at some point officers showed Mr. Tolliver photographs of the crime scene, including images of Mr. Jones. Tolliver stated after several hours of questioning, Tolliver wrote his statement with 1 or more officers present. Tolliver said right before he was told to write his statement, one of the officers got aggressive and physically close while telling Mr. Tolliver he would get the death penalty for the crime. Mr. Tolliver stated he knew what the death penalty was. He didn't want to die, and he did not know how soon they could make the death penalty happen. Tolliver said the officers told him his mother called. Tolliver did not get to speak to her, but the officers told him she said something to the effect of, "Tell the truth." Mr. Tolliver said by 11 p.m. that night he was feeling tired and thought he was about to go home. He said he believed if he wrote the statement, then made the recorded statement, he would go home. Mr. Tolliver stated the officers kept asking questions about the crime and he did not know what they wanted him to say. When he was confessing to the crime, Tolliver said he was not telling the truth because the defendants did not commit the crime. Tolliver said he told the officers something just so he could go home. Now, the rest of these things on here are things that deal with the ineffective assistance of counsel claims that he made because counsel did a very poor job of representing these two men, and as a result, they got convicted. Now, this was all brought to the court in North Carolina on a motion for post-conviction relief. They have a special statute there. And here is what the court said after hearing all of the evidence in the case. It is therefore ordered, adjudged, and decreed defendants' claims for relief as they pertain to Ms. Black's recantation are granted. That's the gal who recanted her testimony that was pressured by the police. 2. Defendants' claims for relief as they pertain to footwear analysis are dismissed, but defendants' claims for relief as they pertain to DNA profiles as newly discovered evidence are granted. Defendants' claims for relief as they pertain to the developments in the fields of adolescent developmental psychology and the psychology of police interrogations and confessions as newly discovered evidence are granted. Mr. Banner's and Mr. Cawthon's claim for relief as they pertain to Mr. Bryant's and Mr. Tolliver's affidavits as newly discovered evidence are denied. Defendants' claim for relief as they pertain to the ineffective assistance of counsel for failure to investigate defendants' mental disabilities are granted. Defendants' claims for relief as they pertain to ineffective assistance of counsel for failure to put on evidence relating to the science of false confessions are granted. Mr. Banner's claim for error as it relates to the commission of a Harbison error is granted, and Mr. Cawthon's claim for relief as it pertains to the commission of a Harbison error that caused the violation of his due process rights is granted. The conviction shall be vacated and hereby dismissed with prejudice on both Banner and Cawthon. The state lost, but it appealed, and for that reason, neither of the two men were released from prison. Then the North Carolina Court of Appeals affirmed the trial court and ordered the men's release. Again, the state appealed, and this time they took it to the state Supreme Court. That court, on October 1, hours before these two men were going to be released from prison, issued an order granting a stay, requiring the men to remain in prison while it considers the state's appeal of the trial court's ruling. Now, the state is going to have to redraft a brief. It's probably going to take months to get this before the state Supreme Court, and probably months on top of that to get a ruling. And that's just not right. 2 of the men convicted are already out of prison because they were convicted of lesser offenses and their time was served. They're seeking a reversal of their convictions to restore their record. While they're not in a jail with bars, they are in a social jail that labels them as convicts. The North Carolina Supreme Court is not doing the right thing here. These men have been in prison since 2004. That's 21 years. All because tactics that were designed to induce confessions in adults were used on minors who likely had no involvement in the crime. Promises were made to get them to confess, and so these scared teens told the cops what they wanted to hear. All these kids wanted to do was go home, and the cops told them, hey, if you tell us the truth, what they wanted to believe was the truth, then they could go home. The cops lied because they were never going to let them go home. But then they got the story they wanted instead of the story that actually happened. Somewhere, a murderer is free and innocent men sit in prison after being literally hours away from freedom. It's just wrong. I'd really be interested in your thoughts about this particular case. What you think? Having gone through the process where you've got a judicial order, even after you've been appealed and you've lost the appeal, it seems to me that there ought to be some grace granted in that situation to allow these men to go home. It's not like they're going to be able to leave the country. They're not going to be able to get passports until this is completely decided. So if for some reason the state Supreme Court reversed this, well, in that situation, they would have to go back to prison, but at least they'd have some time with their families before they did that. Sometimes the law can really not appear to be particularly fair. Sometimes due process doesn't seem like all that fair of a system. Like I said, I'd be interested in hearing your thoughts, particularly about the Reid technique. And I think especially when you think about the detective in the Brandon Isabel case who said, we didn't use the Reid technique. I was never trained on it. The fact is, other detectives there probably were trained, and that's who trained him. It has become a standard model in many police jurisdictions, particularly in larger communities. I do believe that by its very nature, it violates the due process rights of defendants. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee, anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.